Will Donald Trump be a witness in the criminal case against former FBI Director James Comey that Donald Trump directed? One of James Comey's defenses will be based on this vindictive prosecution that Donald Trump continues to call him a dirty cop. Donald Trump posted Pam, referring to his attorney general, go after my political opponents, prosecute Comey and New York Attorney General Letitia James and Democratic Senator Adam Schiff. And Donald Trump is making these posts on a private social media platform, the one that he owns. Okay, Truth Social. It's not like he's making it on Twitter or X or whatever. It's on a platform that he owns, that he has a private contract with the social media company with, in order for the social media company to position itself as having exclusive content. They have a deal with Trump in his private capacity making posts. Trump had previously argued during his first administration, when somebody sued him for blocking them on then Twitter, which is now X, that his @RealDonaldTrump account was purely private in nature and should not be viewed as an actual public account. It was an interesting thing because the Supreme Court eventually dismissed the case as moot when Donald Trump lost the election to former President Biden about whether the @RealDonaldTrump account was public or private. But in the dissent by Justice Clarence Thomas, who of course is a big Trump supporter, he kind of put the onus on Twitter, then as the now X, as the platform, as being the real group in control that should be subject to the subpoenas and all of the regulations, which is interesting because now Trump owns Truth Social, which is, its own intended version of one of these social media platforms. So since the indictment of James Comey, Donald Trump has posted things like, James Comey is a dirty cop, make America great again. He posted whether you like corrupt James Comey or not, and I can't imagine too many people liking him. He lied. It's not a complex lie. It's a very simple but important one. And I just set the record straight quickly. There's really not a good case against James Comey. The whole indictment is based on whether or not during the first Trump administration, James Comey authorized the FBI or somebody at the FBI to leak information to the Wall Street Journal. Then on September 30th, 2020, during testimony where Ted Cruz was asking questions to James Comey, Ted Cruz said, were you aware and did you authorize people at the FBI to leak this information to the Wall Street Journal? And it was the position of James Comey, I never authorized anything. I was made aware of the leak after the Wall Street Journal published this article. I think it was back on October 30th or so of 2016. I was made aware of it on October 31, 2016, but I didn't give authority to someone to do it, but I was made aware of it. And the whole indictment is basically saying, no, you authorized it with somebody. But all of the statements that I've seen from witnesses, whether it's McCabe or Richmond's a DOJ guy, McCabe worked at the FBI. At least what they've said is that we made Comey aware, but never got formal authorization from Comey. So it's a weak case. That's why the case wasn't brought by the former federal prosecutor, the career guy at the Eastern District of Virginia, who Donald Trump forced out and then put in this 36-year-old personal lawyer of Trump, Lindsey Halligan, who's never been a federal prosecutor before. But I want to bring in Harry Litman because I want to talk about this issue. Could Donald Trump, if Comey wanted to, and I'm not sure Comey does or doesn't want to, but, Donald Trump a president would usually make an argument of some sort of executive privilege. Trump could cite the absolute immunity ruling, which is just like, the Supreme Court blanketly saying that, there's not a lot you can get in discovery regarding the president, but go back to executive privilege objections and things like that. But Trump's out there on what I think is a personal account. This is one of the defenses would be vindictive prosecution. Trump's very specifically saying it's a simple lie. I know what it is. So if I'm a criminal defense lawyer and Comey's got one of the best in the biz, or not the best, Patrick Fitzgerald, you've told everybody to do it, right? Yes. You said it's a simple lie. What's the lie? Explain to me the lie and what it is. And Trump won't know what to say there. Even if you subpoena Trump and he asserts executive privilege, which he may, you may be showing, okay, big guy, you said that, like, I may do it just to see if he asserts executive privilege. Or Patrick Fitzgerald may say, you know what? Why turn this into a gong show and turn it into a circus? We're going to win on a very simple case, because who are their witnesses? The guys who like Comey, who said that Comey never authorized him? Like, who are they going to bring in? So let me toss it to you, Harry, about your former top federal prosecutor, the top federal prosecutor in the Eastern District of Pennsylvania. What do you do as a criminal defense lawyer in this case? Who are your witnesses?
Yeah, it's a great question and a sort of complicated one. Let me just start, by the way, by saying, man, I hope some members of the White House press corps are listening, because what a gorgeous question that was. Oh, it's so simple and straightforward. Mr. President, what is the lie that Jim Comey allegedly told? And man, he would step in it 6 different ways. Okay. To the trial. Now, you're right. It's fairly routine. It's often a kind of a sort of a hostage situation to tie the government in knots to say, I've got to talk to the president. And courts routinely turn that down, but for 2 reasons that are a little bit different here. One could be a pure executive privilege, but the executive privilege is to shield legitimate communications, and we're not really talking about, well, I said this to Pam and she said to me. The other more frequent reason would be, you don't just get to talk to the president. Maybe we'll give you the undersecretary of blah 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 who can tell you all you need to know. Guess what? That person can't tell you all you need to know. The only one can be Bondi, because if it becomes, this is the threshold question, and the one that I want to expand on in answering you, how do I try this case? We have the unbelievable situation in which the president of the United States seems manifestly to have issued this order. Now, if it becomes an important, relevant part of the case, can Fitzgerald make it happen? But if there's a kind of a process attack on everything that's occurred, including the best selective and vindictive prosecution I've ever seen in my life, then really the normal reasons for saying, well, it can't be the president, no longer apply, because he is the guy. If you get Bondi up there and said, well, that was my impression of what the president wanted, okay, that's pretty good, but that won't count for the president. So on the one hand, it never happens. On the other, I can't imagine a stronger case. And it goes to this general question. You saw Comey very effectively say in his statement, I'm not afraid. I won't live on my knees. Bring it on. I'm ready. And he made it seem as if, and you can imagine this sort of strategy, what he wants to do is go right away. God knows that they're not ready to try it in the Eastern District of Virginia, which is the rocket docket. And he can say, I want my 60 days. I want to do it right away, et cetera. And there'll be a comparative advantage there. But there's a lot of really rich stuff that Fitzgerald's, I think, just by trying to do your all for your client, is going to want to do. Starting with a bill of particulars, let's get really clear about what you're saying. Then a vindictive and selective prosecution motion. Let's get really clear on what that's about. A motion to dismiss, different discovery, including of this stuff as a sort of separate point from I want Trump on the stand. So he could tie them in knots. And Judge Nachmanoff, whom I know some and who I think he's a good judge, who thinks, he's a former federal public defender and the like. If that's what happened, it would be the obvious strategy in this case, twist it and make it about the government, then sort of all bets are off. And that's how you could see the motion to call Trump. And exactly how you just don't expect it to happen. But I'm trying to think of Nachmanoff's analysis and saying, no, it ain't that somebody else can do it. It ain't that it's not really Trump who's alleged. It ain't that there's not a good faith basis for needing discovery. So all that could, if he's there and they get this straight out. Did you say Did you fire Siebert? Why'd you fire Siebert, et cetera? That could be not only, personally embarrassing, as it always is when Trump steps all over his tongue and any kind of thing like that, but could actually add real force to a motion to dismiss. So I think there's a threshold question, and I think, as you say, Fitzgerald is great. And Comey is great, by the way. Comey was a great lawyer, U.S. attorney in Chicago. Really, I mean, he you've seen him testify. He's going to be a killer witness if he does it. But they'll make a collective decision, and do they want to string things along, take every shot, and make things hard for them, or they want to boom, roll the dice on a jury not taking this really gossamer case. So that's the threshold question on which your question, Ben. Might they actually say we want Donald Trump on the stand? Remember Oliver North case, by the way, criminal case. Reagan had to take the stand in sort of similar ways, and he had this pretty doddering kind of testimony. It can happen.
Give me a little bit of that history, because that blew me away right there. And I'm not going to say,
you mean?
I'm not going to let you know my age when that may or may not, I may not have been born yet.
1989. You're not such a baby. but yes, remember, did North is on trial. What one of the things he's saying is, Reagan told me to do this. I'm carrying out presidential orders. And the judge then, I think maybe in the Eastern District of Virginia. By the way, did you just hear this? 2 weeks ago, boy, is this an aside, but Oliver North married Fawn Hall, his secretary. She was married to someone else, 25 years. Anyway, now they're married. But that was the argument. They wanted Reagan. Reagan's term had ended by then. Yeah. So it was a little bit different, but he took the stand. John Kecker made him look terrible. And he said in closing argument, with great respect to our former president, et cetera, I think you can basically disregard everything that he says. He was doddering. He didn't know what he was talking about. And remember, there was a conviction in that case at the trial level that then was reversed at the D.C. circuit. So,
Harry, my question thank you for clarifying that piece of history. My question for you, though, if you did a vindictive prosecution motion before the trial, you did a motion to dismiss alleged vindictive prosecution, could you then ask for an evidentiary hearing on it where you call witnesses? Because strategically,
discovery, yes.
Right, because I wouldn't want to, my gut is at the actual trial, it would turn it into a bit of a circus, and I don't think you need that. But if I were to do an intermediary step, file a vindictive motion to dismiss, get the discovery, call for Donald Trump to have to take the stand in an evidentiary hearing about his role in orchestrating this, you know what Trump will do. He'll cite executive privilege and he'll try to avoid it. To your point, then this goes up to the Supreme Court. And then, if you're...
I'm not sure it even does. I'm not sure I see the interlocutory appeal here. They maybe have to play it out all the way. But the short answer is that the motion could be accompanied by valid discovery that Nachman off the judge in the case would allow.
I guess my point, without totally geeking out, is that Trump...
let's geek out, man.
Okay, well, let's say that Trump files the interlocutor, that Trump files an executive privilege objection. Judge Nakamas rejects it and says, no, I mean, you injected yourself into this, so you've got to testify. Trump's going to file some emergency.
Yeah, no, you're right. I agree.
And then the Supreme Court this is a highly unusual, blah, 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 blah. So then I guess if you're Comey, as you're playing it out, and these are probably conversations going on behind the scenes, if Trump then avoids the testimony, does Trump then act like he's winning something in this case? But even though it's not a real win. And so your point is a great one, which is, does Comey want to go for this direct shot, bring a jury? You've got Lindsay Halligan. She doesn't know what the hell she's doing. Rack the jury right now. Let's go. Or do you surgically do the things that Comey and Fitzgerald and their legal team can do to really dissect this case and inflict pain? But with that takes time. And do you want to endure this now for 4 years and it having all these permutations? So I'll give you the final word, but that makes a lot of sense.
Yeah, I'll just say this is exactly what they're talking about now. He was strong here, but man, he's under indictment. His liberty is a threat. So getting rid of this quickly, I'm sure, would have an awful lot of appeal. On the other side is you want to take every shot, and it's quite clear at a minimum that there's a really compelling. They always lose, but we have, and this is why the discovery would come, the order given from on high, and I mean on highest. And that's just going to have to, figure in, if you're saying it, and that figures in under the law. So they can't, they would try to say in other situations, maybe we can reach a stipulation or whatever. But, once this comes up, Nachmanoff is going to either be able to say, and he'll want to know the answer, this came from the president of the United States or not. Because, right, they're going to say something like this, don't you think, Ben? Grand jury. I know they're going to try to cleanse it that way. That's not really realistic. And I think a guy named like Nachmanoff, who knows the system, won't call it that way. But it doesn't matter for selective prosecution anyway. If you can establish these things, which almost no defendant can, case dismissed and kind of scarlet letter on Trump's forehead. This is going to be a case, I think, that whatever happens is going to sort of play out and be important in our assessment of who Donald Trump is over the next several years.
Harry Litman, Talking Feds podcast, Talking Feds YouTube channel, and the Talking Feds Substack. Thanks for all the work you do. Everybody subscribe to Harry Litman's various platforms that I just listed there. Start first with Harry Litman's YouTube channel. Search Talking Feds. Thanks, Harry.
Thank you, Ben.
Thanks, everybody, for watching. Now hit subscribe, and let's get to 6 million subscribers.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.